Hello and welcome. This is Source of Income Discrimination. I'm Kara Broadfair and I'm a senior counsel at the California Civil Rights Department in the Outreach and Education Unit. Before we get started, I'm going to give you what I call my boring lawyerly disclaimer. And basically what I'm saying is that we are giving you this information for informational purposes only. We're not giving you legal advice today. We're not establishing policy. And just so you know, the law is always changing. And while this information is recent as of the day that I'm recording it, it can change at any time. So just keep that in mind if you're going to rely on this information. Before we get started, let's go over our agenda. First, I'm going to talk about what we do at the Civil Rights Department, including the laws that we enforce that have to do with housing. Then I'm going to talk about the Section 8 program, and then I'm going to talk about source of income discrimination and how it can play out in real life. A little bit about the Civil Rights Department. We are California's civil rights agency because we're the state agency that is charged with enforcing laws that prohibit discrimination in housing and employment by businesses. We also enforce laws around human trafficking and hate violence. And, we have a large job because it's our job to enforce these laws for everyone in California. How do we do that? So we enforce the laws in a variety of ways. One, we are probably known the most for being the state agency that people can file discrimination complaints with. If you think that you've been discriminated against in housing and employment or by a business, or there's been a violation of other laws that we enforce, we take these complaints and we look into them. And we often get people together, the parties that are in dispute about the discrimination, and we try and get them together to come to some type of agreement or resolution. We often also go to court to prosecute violations of the laws that we enforce. We also have a civil rights council, and they are a group of experts who take the laws that we enforce and they write regulations to tell people a little bit more about how the laws really play out in real life, what people's rights and responsibilities are. We collect data on the pay and demographics of people who work at large employers in California. We do outreach and education, which is obviously what I'm doing right now. And we work with communities to do community dispute resolution. So we do a lot, and we actually do more even than what I'm mentioning here. Here's some information about accessing our services if you are a person with a disability. If you'd like to request an accommodation to access our services, here is the contact information that you can use. Similarly, here's information on how you can access our services in other languages. You can call us and on the phone request a language translation services, or there's an email here and other ways as well. So let's go into the laws that we enforce here at the Civil Rights Department. The main law that we enforce is the Fair Employment and Housing Act. This is the law that protects people from discrimination in housing and employment, and it protects people based on having protected characteristics, and we'll go into what we mean by that. And this law also protects people from harassment based on protected characteristics. We in California also have the Disabled Persons Act, and this gives people with disabilities or medical conditions the same right to public accommodations in public places. We also enforce the Unruh Civil Rights Act. This prohibits discrimination based on protected characteristics by businesses, and those businesses include people who provide housing. And we enforce a law called Government Code 11135. It doesn't have a snappy name. And this law basically says that if you take money from the state of California, you cannot engage in discrimination. List of the protected characteristics in housing in California. What we mean by a protected characteristic is something about a person that's usually pretty central to their identity or who they are. And in California, we have a number of protected characteristics that if somebody discriminates against you because you have one or more of these characteristics in employment or housing or by a business, they would violate the laws that we enforce. There's also the Fair Housing Act. That's a law that covers the entire United States. And the Fair Housing Act includes some of these protected characteristics, but in California, we have many more protected characteristics. And those include source of income discrimination, which is what we're going to talk about today. It also includes gender identity, gender expression, primary language and immigration status, and citizenship. But again, this covers all protected characteristics under the law. And these protections can be that you actually have these protected characteristics, if you're perceived to have one of these protected characteristics. So, for example, we had a case where somebody assumed that a family, because of the way they looked, were undocumented, and this housing provider discriminated against them. And even though they weren't undocumented, because they were discriminated against because the housing provider thought they were undocumented, they were still protected. We also protect people who are associated with a person with a protected characteristic. So, for example, if you are a parent of a child with a disability, you would be protected from discrimination based on that association. We also have what I like to call rights that flow from protected characteristics. First, you have a right to be free from harassment where you live based on your protected characteristics. You have a right to operate a licensed childcare in your home that you rent in California, and we'll talk more about that. And there's also specific protections for people with criminal histories who are looking for housing. So let's jump in. I'm going to give you a background on the Section 8 program to make it easier to understand, how these protections play out for source of income when it comes to people who are using Section 8 vouchers. So just to start, here's some basic information about the Section 8 Housing Choice Voucher program. Section 8 vouchers, they are used across the country. They're funded by the federal government, and they're designed to make up the difference between the cost of living and the incomes of low-income households. So basically, what they do is they cover a portion of somebody's rent when you take into account their income. So they make up the difference between 30% of a person's income and the total rent. And a voucher holder can take the voucher and use it to rent in the area covered by the housing authority that issues that voucher. So for example, I live in Oakland, and if I got a Section 8 voucher in Oakland, I could use it to rent a home in Oakland. There is also a right to what they call port your voucher at a certain point and take it somewhere else. I'm not going to get into that, and there's a lot to know about that, but you can use your voucher, technically, across the country. The reason behind the Section 8 program is to give voucher holders what we like to call housing choice, basically to give people a right to choose where they live. And where you live has a really big impact on your life. So it's important for people who are looking for housing to be able to choose, where they're going to lay their heads at night. And unfortunately, due to many factors, including source of income discrimination, voucher holders to this day are still very segregated to low income and low resource areas. 75% of new vouchers have to go to what the law calls extremely low income households. These are people that make less than 30% of the area median income or the average income in an area. So for example, the area median income in Alameda County for a family of 3 is $128,500, and an extremely low-income household would earn about $38,600 or less. So very, very low income. And as I said, the vouchers are administered by the federal government, by the Department of Housing and Urban Development, and HUD contracts with local public housing authorities to administer the program locally. So how hard is it to get a Section 8 voucher? This might surprise you. It's very, very difficult. The need for Section 8 rental assistance is huge and it's increasing. Only 1 in 4 households that qualify nationally have a voucher, and the need in California is even worse than that. There's about 307,000 Section 8 vouchers in California, but according to recent estimates, more than 1.6 million Californian households pay more than 50% of their income on housing. And just so you know, the government says that if you pay more than 30% of your income for housing, your housing is unaffordable. And because so many people in California are paying so much more for their housing, they often forego necessities, things like food or medicine, in order to keep a roof over their heads. Also, wait lists for vouchers are often 3 to 5 years or more. An example is in Los Angeles, the Public Housing Authority a few years ago opened applications for their wait list, and the wait to receive a voucher is still up to 10 years or more. This means that, if you lose your voucher or can't use it, it can be devastating and can really mean the difference between having a place to live and being homeless. So how is a voucher tenant's rent calculated? So a tenant can rent any unit as long as it's within what the law calls the payment standard. And this is a standard set by the Public Housing Authority. And it has to be basically within an amount calculated by HUD. And what they do is they look at comparable housing in the area that you are using your voucher, and they figure out what the maximum amount that they will pay is. So this is the payment standard from 2022 for the county of Kern. So for example, in Kern, the housing authority would pay up to $915 for a studio, $925 for a 1-bedroom, and then it goes up from there. So how is a tenant's rent calculated? So I talked a bit about this already, but a Section 8 voucher covers the difference between 30% of a family's income and the total cost of the unit as long as it's within that payment standard. We'll do some examples so this makes more sense. So here's a hypothetical, the Stark family. Winterfell's PHA's payment standard for a 2-bedroom apartment is $2,100. The Stark family's total monthly income is $1,800, and they want to rent a 2-bedroom unit that costs $2,000 a month. So how much would the Stark family's rental payment be? And if you're scratching your head, it's okay. This is kind of a hard thing to do on the fly, especially when you're learning about it. But the answer is $540, and I'm going to explain why. So the home the Stark family wants to rent, it's within the payment standard. They're able to rent a house with a rent up to $2,100. So the family's rent would be calculated as 30% of their total income. And so 30% of $1,800 is $540. And the housing authority or the PHA would cover the rest. So the Stark family would pay $540 and the housing authority would pay $1,460. So here's another hypo. This is Teresa. After 5 years on the wait list, Teresa has just received a Section 8 voucher for a 1-bedroom unit. The housing authority's payment standard for a 1-bedroom is $1,500. Teresa is disabled and receives $764 a month in SSI. So 30% of her income would be $229.20. Teresa has been having a lot of difficulty finding a unit to rent. She finally finds something, but she's dismayed to find out that the landlord wants to charge $15.50 a month, or $50 higher than the payment standard. So is Teresa allowed to rent the unit? So basically here, Teresa wants to rent a unit that's outside of the payment standard. So yes, Teresa can still rent this unit. If a new voucher holder is looking for a new place to live, or someone who has a voucher to go and look for housing, they can actually pay up to 40% of their income to make up the difference between the payment standard and the available unit's rent. Keep in mind that the federal government and many experts say that paying more than 30% makes housing unaffordable, but Teresa can choose, I guess, if you want to call it a choice, to pay up to 40%. Here and often with many Section 8 voucher holders, you're really just trying to find a place that would work, and it doesn't always fit within that payment standard. So this means that Teresa can pay up to $305.60 a month. That's 40% of her income. So her monthly payment would be $229.20. 30% of her income plus the extra $50 in rent. So if that would be a total rent of $279.20. So I hope that's helpful. I know I'm doing a lot of math here. Also, the law does allow for people with disabilities who have a disability-related reason to rent a particular home. Maybe it has accessible features. Teresa utilizes a wheelchair, and maybe she found a unit that has wide doorways and is accessible for her wheelchair. She can make an argument to the housing authority that, this unit is accessible and I have been unable to find other accessible units, and I'd like a reasonable accommodation for what's called an exception to the payment standard. This means that she can request the housing authority to pay more than what they normally would pay in order for her to find an accessible unit. So after 1 year, Teresa's rent is increased to $1,600. This would make her monthly rent more than 40% of her total monthly income. So can Teresa stay in her unit if she chooses to pay the difference? And the answer is yes. So after a year, a voucher holder can choose to pay more than 40% of their income. Again, this unit is already unaffordable, and if she's paying more, it would continue to be unaffordable. But, Teresa, if she was a real person, would probably be weighing this with the difficulty in finding a new home and one that meets her needs, especially as someone with a disability. So yes, she can stay and pay more than 40% of her income. So let's talk about how the Section 8 process works when someone wants to use a Section 8 voucher to rent a home. How does that work? So first, the person goes around, they look at units, and they talk to the landlord. The landlord agrees to rent to them, and then they sign what's called a request for tenancy approval. And this has basic info about the property, the size, the rent. And then the housing authority inspects the unit to ensure it meets minimum standards. They're called HQS, or housing quality standards. And these are standards set by HUD on the federal level. And some people are concerned because sometimes it can take a little while for these inspections to happen, and we recognize that. A lot of housing authorities are doing some great work to make this process more seamless and quick to get somebody into a unit quickly, because they know that time is of the essence for everybody. And then the landlord and tenant sign a lease agreement, and there is an addendum, or just like another part of that lease agreement. It's required by HUD, and it basically just has some rules and agreements that govern the Section 8 voucher program. The landlord also signs an agreement with the housing authority because they're going to be making payments to the landlord as well. And the tenant moves in and the payments start. So that's just a little background on the Section 8 program. I know I got a little in the weeds there, but I think it will be helpful when we talk about source of income discrimination. So what we mean by source of income discrimination is discrimination based on how somebody is going to pay their rent. And in California, income has a really broad definition. Income can mean, money that's paid directly to a tenant, so money they get from public benefits, money they receive from working. It can also include money paid to a representative of a tenant, so some people have disabilities where someone else manages their money. Also, it could be money paid directly to the housing owner on behalf of the tenant. This includes many types of rental assistance, which also includes the Section 8 voucher program that we just spent a lot of time talking about. So again, this means that a property manager can't discriminate against a tenant based on how they're going to pay their rent. And this doesn't mean that housing providers can't ask where income comes from or how much someone makes. They just can't use this information to discriminate against somebody based on, where their income comes from. So, for example, a housing provider can ask, can I get pay stubs from you to show, where you work and how much you make, or, a certificate or a letter about how much benefits people are receiving monthly. They can ask for that and they can consider that amount because many housing providers do have certain income standards. They can do that. They just can't discriminate because, the money comes from, for example, public benefits. So here's another hypothetical. This is Bashir. Bashir has a Section 8 voucher and applies to rent a unit from Ariel. Ariel looks over Bashir's application and she says he can have the apartment, and she knows he has a Section 8 voucher. But the next day, Bashir gives Ariel the paperwork from the housing authority to fill out. We went over that was that first form that the housing provider fills out about the size of the unit and bedrooms and rent. Ariel gets annoyed and tells Bashir, I have absolutely no problem with you using a Section 8 voucher, but I'm not jumping through additional hoops. I'm not filling out this paperwork. So do you think this is a violation of the law? The answer is yes. So let's talk about it. So saying outright, I'm not accepting a Section 8 voucher is obviously discrimination, but also taking steps to basically make it impossible for somebody to use a Section 8 voucher is also discrimination. And here, Ariel is refusing to complete necessary paperwork, and she says she's not going to jump through those hoops, and that's essentially her saying, I'm not accepting Section 8. Also, obviously having an advertisement that says no Section 8, no HUD, no public assistance, evicting a tenant because they finally get off that long wait list for Section 8 and receive a voucher, or, not renewing somebody's lease because they have a Section 8 voucher. So here's another hypothetical. This is Sasha. Sasha is applying to rent a 1-bedroom, and she's going to use a combination of a local housing subsidy and her monthly public benefits to pay rent. She receives notice that her application has been rejected because, one, she cannot provide 3 months of pay stubs from employment, and two, she has an eviction on her record. So do you think the housing provider violated the law for rejecting her because of her lack of employment pay stubs? The answer is yes. Here, the housing provider is basically stating that they have a preference for where her income has to come from. They're saying that you have to have a job to live in that house or that apartment, and that is against the law because it's discriminating against somebody based on where their income comes from. Here, Sasha, would be able to cover the rent with a combination of her public benefits and rental assistance. And so the housing provider cannot say that they're not going to rent to her because she doesn't have a job. And what about the eviction? The answer is the housing provider can decide to not rent to her because she has an eviction on her record. So housing providers are not required to accept all applicants that have housing subsidies. This is kind of a misconception that people have. As I said before, landlords are still free to consider other lawful factors when analyzing a rent application. They can look at, how much somebody makes. They can look at someone's credit history, although there's some new laws that impact that a bit. They can look at their rental history, if they have an eviction on the record. They can also look at their conviction history, although there's some laws that prohibit certain types of inquiries there as well. But when analyzing whether an applicant has enough income, the housing provider has to consider all legal sources of income, paid, money that the tenant has, money paid on behalf of the tenant, like rental assistance. They can't discriminate based on where that income comes from. And as I said, there are some exceptions now to checking someone's credit history. As of January 1st of 2024, housing providers are required to give people who are using rental assistance, like Section 8 vouchers, the opportunity to provide lawful and verifiable evidence of their ability to pay rent, and they should do this before running a credit check. This means that housing providers have to consider, evidence and documentation of someone's ability to pay rent, looking at things like pay stubs or benefits documents or other verifiable sources of income. And if that shows that somebody can meet their obligation under the rent, then that housing provider should consider that information and not run and do and consider a credit check. So if this evidence is provided, the housing provider must consider this instead of credit history. Here's another hypothetical. This is Octavio. Octavio has a Section 8 voucher and applies to live in a 2-bedroom with his partner and children. The rent for the unit is $2,500, and Octavio's portion of the rent would be $450 because he has a Section 8 voucher, and 30% of his income is about $450. So he would be paying $450, and the housing authority would be paying the rest, up to $2,500. The landlord denies Octavio's application because she has a policy that applicants have to make 3 times the monthly rent to qualify. So that's 3 times that total monthly rent of $2,500, which would be $7,500. So did the landlord violate the law? And the answer is yes. So landlords are free to have a minimum income that's a multiple of the monthly rent, but when they are applying this to people with rent subsidies, they are only able to consider that person's portion of the rent. So here, they can consider if Octavio makes, 3 times his portion of the rent, which he would because it's set at 30% of his income, but they can't consider 3 times the full monthly rent, because that's essentially saying that a person could never use a Section 8 voucher. So I hope this is helpful. This is a law that's been on the books in California for a little while. Here's another example. I'm hoping that this is helpful as well. It involves a person named Penny. She applies to rent an apartment with a monthly rent of $2,000, and the housing provider has a policy to only accept tenants who earn 3 times the monthly rent. Penny's portion of the rent is $200, so that means the housing provider can look at Penny's income and consider if she makes 3 times her portion of the monthly rent, which would be $600. Who knew that you were going to do so much math in a legal presentation, right? All right, let's move forward. So this is Rabia. Rabia has a Section 8 voucher, and she applies to live in a 3-bedroom home with a monthly rent of $3,200. The landlord looks up the payment standard and sees that it is capped at $3,000 a month. She rejects Rabia's application, telling her that it's outside of the payment standard. Did the housing provider violate fair housing law? And the answer is yes. So it seems here that the housing provider, was a little more sophisticated than other landlords in that they knew what the payment standard was, but they cannot themselves look at what the payment standard is and decide whether or not it will work for the unit, because it's not the only factor that determines how much rent can be paid. We already talked about how somebody can choose to pay up to 40% of their income in rent, which means Rabia may be able to make up that difference. She might have another reason why she can get assistance in excess of what the payment standard is. I talked about how they can ask for an exception to the payment standard because of a disability. So, here the housing provider did violate fair housing law. They should not be doing that calculation because it's not just based on that one number. But note, the housing provider could still, have a minimum income, but it should just be, as I talked about before, a standard based on Rabia's portion of the rent. So let's do another hypothetical. This is Lynn. Lynn puts in an application to rent an apartment from Sarah. Lynn mentions that she will be using the house to run a small licensed childcare. Sarah denies her application, stating that the other tenants will be unhappy about the noise from the children. And did Sarah violate fair housing law? And the answer is yes. So I think this might be a surprise to some of you, but providing childcare in one's home is in California considered to be a residential use of property and is protected. And because it's her source of income, it's also source of income discrimination. So here's some protections that apply to family child care providers. And this only includes people who are licensed child care providers. You can get a license for doing childcare at home. There's a small license and like a larger license. So if somebody has a license, they shouldn't be discriminated against. A refusal to rent or otherwise. So landlords can't refuse to rent, evict, or raise the rent because a tenant will be operating a licensed family child care home. These protections also apply to somebody who is purchasing a home or someone who is renting a home that has a HOA, so it's a condo or a homeowners association. They also apply to realtors and mortgage lenders. So, say somebody is looking at a home and they talk about, wanting to operate a licensed childcare, that seller can't refuse to sell it to them because they're going to be using the home for that purpose. So that's the end of the main part of our presentation, and I appreciate you sticking with me, especially with all the numbers that I used. Here are some resources that you can get to. We have fact sheets on source of income discrimination. We have a short one and a long one. We also have a fact sheet specific to home childcare providers. I also want to let you know that we do monthly webinars 3 times a month, and these webinars are free to attend, and you can find information on that on our website. And these webinars cover things like this training on source of income. They cover other housing discrimination areas like fair housing basics, criminal history protections, protections for people with disabilities. We also do webinars on other topics like employment discrimination and the other laws that we enforce. So I highly recommend checking those out. It can be, helpful to go to a live webinar because you'll be able to ask questions. But again, I'm really glad that you stuck with me for this presentation, and hopefully, you'll be back for another one. So thank you so much for your time.